So what if the Constitution guarantees citizenship, but nobody can agree what that means? Right now, birthright citizenship is back in the headlines after a recent Supreme Court decision that actually didn't settle the question at all. So we should probably look to see where this idea comes from, and more importantly, what does history actually say? Today's debate centers on one line in the 14th Amendment to the U.S. Constitution, and it says that all persons born in the United States and subject to the jurisdiction thereof are citizens. That sounds simple, doesn't it? But it's not. Supporters argue that this guarantees citizenship to nearly everyone born on U.S. soil. But critics argue that the phrase subject to the jurisdiction limits that rule. It limits the rule, especially in a world of modern immigration law. But here's the key. When that sentence was written in 1868, none of today's immigration categories existed. There were no visas, no green cards, no illegal versus legal framework. So to understand that debate, we can't anachronize. We must go backward and see what was what. Now, the strongest foundation for birthright citizenship doesn't start in America at all. It starts in England. In Calvin's case, which I discussed at length in a recent video, go watch it, the British courts established a powerful idea. If you're born under the king's protection, you owe allegiance. You are a subject. Now, we've inherited this. If you were born in the U.S., you are under, temporarily or permanently, the protection of the U.S. government, which is to say the people. We, the people. Now, legal thinkers like William Blackstone, he summarized it simply that children born in a country are generally citizens, no matter who their parents are. Why? Well, because of deeper principles rooted in the Enlightenment and the philosophical thoughts that flowed from the Enlightenment, including those thoughts from John Locke. Locke has posited that governments exist to protect the people. People owe obedience to the government in exchange for protection, and individuals have natural rights like self-preservation, the freedom of movement, and the freedom of association. And even earlier documents like the Magna Carta helped establish the idea that sovereign power is tied to legal obligation, not just bloodline. Now, this became known as the doctrine of jus soli, or jus soli if you're an English-speaking goober like me. And that means citizenship by place of birth. Now, early America inherited this system. In fact, the U.S. originally operated under something very close to the freedom of movement. People could come and go with relatively few restrictions. Treaties even recognized migration as a natural right. And this matters. It matters because the framers of the 14th Amendment weren't debating illegal immigration as we understand it today. Instead, they were asking who owes allegiance, who receives protection, and what happens when those two things meet at birth. When Congress debated citizenship in 1866, they didn't all agree. Who does? Senator John Conness argued clearly that children born in the U.S., even to Chinese immigrants, which was a big hot topic at the time, should be citizens. But others raised concerns about allegiance. Meanwhile, President Andrew Johnson, he vetoed the Civil Rights Act of 1866. He warned that it would grant citizenship too broadly. But he also pointed out something very crucial. Some Americans already believed birthright citizenship existed naturally, without legislation. So for Johnson, it was a moot point to sign it into law. Others believe Congress was creating birthright citizenship for the first time, and that disagreement still echoes today. Here's the surprising part. Almost nobody in 1866 talked about temporary visitors. Why? Because that category barely existed. There were no modern tourists, no visa overstays, no chain migrations, and no birth tourism, a hot topic for today. Just what was called alien friends, meaning foreigners peacefully present under U.S. protection. And chronology wasn't even a factor. So the biggest modern question, what about the children of temporary visitors, was largely left unanswered then and now. If temporary visitors had been frequent enough, or even discernible in the 19th century, it is possible that they would be classed like dignitaries, that their children would not be counted as citizens, despite the generally fluid nature of migration at the time. But then came the precedential case in 1898 that interpreted birthright citizenship as belonging to anyone except for the children of dignitaries. This precedential case, this most important case, the United States versus Wong Kim Ark. Wong Kim Ark was born in San Francisco to Chinese parents who were long-term residents but not citizens of the United States. And when he tried to return to the U.S. after visiting his parents and trying to secure a wife in China, the government said he wasn't an American. But the Supreme Court disagreed. It ruled that the 14th Amendment followed the English common law rule that birth on U.S. soil is generally equal to citizenship, with some narrow exceptions, children of diplomats and children of enemy occupiers. But it never directly answered the modern question about temporary visitors. Even outside the courts, the issue created real dilemmas. In 1889, immigration officials tried to deport a poor immigrant mother named Nellie Wilkie, but her child was born here and was a U.S. citizen. Treasury officials ultimately allowed her to stay, saying that the government should not sever the sacred ties between a parent and a child. And that shows something important. Birthright citizenship wasn't just a legal theory, it shaped real human decisions about family, rights, and belonging, things we should take into account today. Sadly today, the U.S. often deports citizen children just because their parents lack legal status. So where does this leave us? History gives us two competing traditions. First, the broad view says that citizenship comes from birthplace, rooted in centuries of common law and natural rights, those inalienable things endemic to all people for just being people, born free. And then there's the narrow view, which says that citizenship depends on full political allegiance, not just physical presence. And the truth, the historical record doesn't fully resolve the modern question. That's why the debate continues. Not because history is silent, but because it speaks in more than one voice. My voice, my personal take, gives deference to human natural and inalienable rights. The freedom to move where you want to for whatever reason, especially self-preservation, with the freedom to associate with whatever nation a person wishes to join. To understand the original framework, we need to think in old terms, in 19th century prior terms. And that big term here is natural rights. Philosophers like John Locke argued that human beings possess inherent rights, including things like self-preservation, the freedom of association, and more crucially, the ability to move and choose where to live, as I concur. But this wasn't just theory. It actually showed up in U.S. law. In 1868, the United States signed the Burlingame-Seward Treaty with China. And in Article 5 of that treaty, both nations recognized something remarkable: the inherent and inalienable right of man to change his home and allegiance, and the mutual benefit of free migration. This is critical. At the exact moment the 14th Amendment was being adopted, the United States was officially affirming movement between nations as a natural right, migration as not inherently suspicious but beneficial. and that people present in a country are under lawful protection, not as legal anomalies to be sifted and categorized to death. In other words, the legal world of 1868 assumed something very different from today. People could move, and that movement itself was legitimate. Since then, we have inherited immigration laws that focus more on privilege than inalienable rights of movement. Now, I will address that at length in a future video. But for this week, I leave you with this. I want to know how you might reconcile the tension between accommodating historical birthright citizenship and the novel idea of temporary visitors having children on U.S. soil. What do you think? Like and subscribe. I really hope you do. And we'll see you next time.